afternoon, everyone. Today we're going to talk about asylum, what it means to file for asylum. It's the basic information as far as an immigration form of relief through the asylum process. So without further ado, Asylum 101. So basically there are two paths to claim asylum. You have the affirmative asylum path and the defensive asylum path. Now, the more favorable way to do to file for asylum would be the affirmative asylum path, because the jurisdiction, meaning the person who adjudicates your case, the entity that handles your case is a USCIS, and the USCIS is part of DHS. And basically you petition with them, you apply using the same application, the 589, you're able to apply for asylum. Let me go back there because it's a bit confusing, but so when you come into the United States and you're seeking asylum affirmatively, meaning you are not in removal proceedings, you did not get caught in the border, you came to the United States with a visa, for example. I have a case currently where a Venezuelan came to the United States using their visitor visa, and once they were here, they filed for asylum. They entered legally and filed their application for asylum to the USCIS. And then you have the alternative, which is the defensive asylum. So defensive asylum essentially means that you are currently in removal proceedings, and you're using it as a defense, so you are not removed from the United States. The Executive Office for Immigration Review handles a defensive asylum claim. It is a length, both affirmative and defensive asylum are lengthy, but again, the more favorable one is the affirmative path, because you are not actively in removal proceedings. When you are in defensive, when you're claiming asylum defensively, you are in removal proceedings, and you're in removal proceedings because you were either caught in the border or by CBP and were placed in expedited removal process, but you were found to have a credible fear of persecution by an asylum officer. So let's go on to the next slide. So to file an asylum claim affirmatively, you need to be eligible, and to be eligible, you need to be physically present in the United States. You do have the option for derivatives with an affirmative asylum claim. And so the way it works is any immediate family members present in the United States may be included in the original asylum application and will automatically receive asylum when the asylum office grants asylum to the principal applicant. So in my scenario with a Venezuelan, if they came here to the United States with their U visa, again, came here, not U visa, with their visitor's visa, came here legally and applied for asylum because they don't want to go back to Venezuela affirmatively through USCIS, they can petition for add their family members. If they came with family members, they can add them into the application as derivatives, and they would also receive the benefits of that come with asylum if it is granted by USCIS. And then you do have to file it within a year of your arrival, unless there's an exception, and one of those exceptions is the changed circumstances that materially affect your eligibility for asylum, or extraordinary circumstances relating to the delay in filing, and you filed within a reasonable time given those circumstances. So it's pretty, from practice, it's that 1 year requirement deadline is pretty strict unless you can change, unless you can demonstrate extraordinary circumstances. So for an affirmative asylum claim, the burden of proof is on the applicant to establish that he or she suffered past persecution or has a well-founded fear of future persecution. And past persecution could be for on account of race, religion, nationality, membership in a particular social group, or political opinion. And now, falling back to my example from the Venezuelan, she fled Venezuela because she is a member, an active member to a political party. The political party is Primero Justicia. And so they are in opposition with the current government of Venezuela. And she did suffer. She was, on her asylum claim, she explained that she was being targeted because she is an active member of this political party, which again is against the government, and the government is not doing anything to aid or help her in Venezuela. Essentially, they are furthering the persecution of that person because she is in opposition of the current government. But it could also be for race. You can be established persecution because of your race, or because of your religion, or because of your nationality. And then the tricky one is the membership in a particular social group. It's a very subjective definition. You can be, you would have to establish that you're part of this social group, and because you're a part of this social group, you're being persecuted. You're being persecuted. And so the testimony of the applicant, if credible, may be sufficient to sustain the burden of proof without corroboration. So the asylum process affirmatively, again, this is all affirmative. So you are with the USCIS, essentially fighting for a grant, for them to grant you asylum. One of the reasons why people tend to fail in their claim, their affirmative asylum claim, is because of the interview with the asylum officer. That's part of the process in the affirmative application. So you submit your application, and then you're scheduled an interview with an asylum officer. And in that interview, the asylum officer will ask you questions to try to determine whether you do have an actual valid claim for them to grant asylum or not. A lot of the times people go unrepresented, so they have no representation legally. And when they go to these interviews, if they're not prepared for these interviews, what happens is their statements are inconsistent, or the asylum officer finds their statements to be inconsistent with what they applied, with what they said in their application. So for example, falling back again to my Venezuelan client, the Venezuelan client applied affirmatively. So she came to the United States and was able to apply within that 1-year deadline for affirmative asylum. So when she submitted her application, and then she was scheduled for her interview with the asylum officer. Well, when she went to the asylum officer, what she had on the application was inconsistent with what she was saying during the interview, during her testimony. So the asylum officer, the asylum, they have discretion to deny or affirm your claim. They believe that her claim was, or her testimony live in person during the interview, was inconsistent with what she had written on the application. So because the asylum officer saw inconsistencies, what happened was they denied her asylum case and now referred it to the immigration court, which then, as I stated earlier, now it becomes a defensive asylum claim. So even though she started as an affirmative asylum claim, because the officer found her testimony to be inconsistent with what she had on that application, he referred her to the immigration judge, the EOIR, and now she has to establish an asylum claim defensively, so she's not ordered removed. So yes, you can end up defensively if an asylum officer determines that he didn't find your interview credible. So let's go here. Let's go to the next one. And I just spoke about it. You know, they have their discretion to deny or to grant your application, and if not, it goes to the EOIR. And again, as I stated earlier, if the applicant cannot, establish persecution, well-founded fear of persecution, again, on account of race, religion, nationality, membership to a particular social group or political opinion, or the applicant or the officer determines that the applicant can avoid future persecution by relocating to a different part of the country. So for example, it's going back to Venezuela. Venezuela as the country as a whole, it's going into political turmoil. So it's very difficult for this specific client. And she actually did move from one part to another, and she was still being persecuted. But that would be on the government to prove that they're able to avoid that persecution by moving to a different part of the country. And as I stated, one of the main reasons why an affirmative asylum officer denies an asylum claim affirmatively is because of the inconsistencies with the person's testimony during the interview and what the person placed in the application. Now, I do want to note that there are many times where, whether it be, actually, no, let's just start with affirmative. Or let's continue with affirmative. So individuals try to file affirmative asylum claims using a notary, so a notario. Unfortunately, a notario is limited in his or her knowledge when it comes to what they should really place in those asylum applications. Perhaps they don't have a valid claim for asylum. I don't know. But at the end of the day, they write down whatever the person tells them, whatever the applicant tells them to write down, without really going into detail. So falling back again on the client that I have who's Venezuelan, what she said on that application, which was filled out by a notario, was very different with what she was saying in the interview, in terms of crucial dates. And so because they were not on the same page, the notario and the applicant were not on the same page, when she went to the interview by herself without the notario, what she had on the application was very inconsistent with what she was saying live in person. And had she perhaps obtained legal representation, he or she, the attorney, would have been able to better prepare the applicant throughout the process. And another situation in where people are placed in removal proceedings through asylum is because they want to obtain a work permit. So a lot of clients, we've come across a lot of clients who think that a work permit is like the saving, like they're saved from removal. They could stay in the United States because they have this work permit, and they hear through other people like, yeah, if you apply for asylum, you'll be able to get a work permit and then you can work. And well, that's true. Part of it is true. I mean, you may be granted a work permit, and maybe you do have authorization to work. However, if you were never in a position, if you were never placed in removal proceedings, and now you filed an asylum application, and there are no facts, there's no evidence to have a strong application, or excuse me, a strong asylum claim. What happens now is that this person that perhaps was not under the radar of immigration or in removal proceedings is now in removal proceedings. So yeah, they may receive a work permit because they filed for asylum, but that work permit is only limited to the extent of the process. So if that, for example, let's say you apply for asylum, but your claim is very weak, there's no evidence for you to establish that past persecution, then the court will deny it, will deny your claim defensively. And what happens after that is your work permit is gone. You no longer have, I mean, the work permit is limited to the amount, to the process of asylum. So it's very temporary, and people unfortunately get caught up in the work permit idea and that it's some kind of safety net to not be removed, but that's not the case. And there are people who do take advantage of the situation. A very common example is the Notario Fraud. So a notario will tell you, yeah, you definitely have a case. Let me just fill out this application for you and you're going to get a work permit. But that's not true. I mean, to the extent that you don't have a strong case, you're placing yourself under the radar, and now you're in removal proceedings and you weren't before. So long story short, legal representation is crucial when it comes to whether you want affirmative or you're on path to for defensive asylum. I think I already mentioned all this. Yeah, so there is an option for derivatives for defensive asylum claim. Now, again, a defensive asylum claim is that you are placed in removal proceedings or you were referred to the court by a USCIS officer who said, no, you don't have a valid affirmative asylum claim. But you essentially get a second shot with the court now to be granted to seek that relief, asylum relief. So yeah, so either it's a USCIS referral or the individual's in removal proceedings, taken into custody. And then for derivatives, it has to be immediate family members present in the United States who are in removal proceedings with the primary applicant. And then other forms of protection are withholding of removal and CAT. So with withholding of removal, it's just there's a pause to you being removed if granted. However, there's no path to legal permanent residence. You cannot obtain a green card with asylum. You can, but with withholding of removal and CAT, there is no path to legal lawful permanent residence. And then more likely, you just have to establish more likely than not that you will suffer future persecution. And then with CATs, the same thing. That's the Convention Against Torture. If granted, it's temporary, and there is no path to lawful permanent residence. So I think I'm pretty much done. That is Asylum 101. I narrowed it down to seven slides. However, this is it is a complex area of immigration, and there are a lot of moving pieces and a lot of lack of communication between those moving pieces. So the recommendation, as an immigration attorney, is to find legal representation, if possible, get some advice from someone who's actually practicing the field, because not being prepared when it comes to the asylum interviews with the officers can be very detrimental to your claim. And so obtain, if possible, an attorney for legal representation when it comes to asylum claims.